Okay, guys, we're going to review the BRBC, the Buyer Representation and Broker Compensation Agreement. It is part of a 13-page bundle that is going to be required after the 17th and probably should be used right now because you're starting to see some of the listings drop off the buyer compensation. So you should be considering using this now. Let's go through the 5 pages. The first 2 pages are the standard AD, which you're very familiar with, disclosure regarding agency relationships. So you've got 2 pages of that, and then you get into the buyer representation and broker agreement. So I'm just going to sort of walk you through each of the paragraphs so that you understand what it's all about and how you'll be using it. So date prepared up top here, that's obviously the date that you're putting it together. Right to represent will be the client, Grants, Coldwell Banker, Skyridge Realty as the broker. And then you've got the new form has the same matrix that's become popular with the purchase agreement. We've been using it for multiple years. The residential listing agreement just changed over as well. But this is the same setup where you have all the important information in the grid. And that takes up, the first section. And then as you go deeper into it, you'll notice that over here on the left, in this column, it gives the paragraphs later on down in the boilerplate that explains any of the important information or expounds on what the meaning of the paragraph is. So you've got the important information up front, and then you have the boilerplate following. So we'll work through both of those as we go. So representation period, you have to have a beginning date and an end date. If you forget one of these dates, it invalidates the agreement, and the agreement could be considered void. So make sure that you do have 2 dates here and that it does not exceed 3 months. Okay, it's not a number of days, it's actually a 3-month period. Then the next section is the type of representation, and this is pretty important. So it defaults to non-exclusive. If you want the agreement to be exclusive, in other words, you want to be monogamous, and you want to be committed to the buyer and the buyer committed to you, then you would check exclusive. And then in turn, under paragraph 15, further on, there's additional explanation of what exclusive means so that the buyer has to initial and acknowledge that. So it's kind of a foolproof where the buyer can't come back and say, well, you didn't tell me this. It's forcing them to have to acknowledge in a couple of spots. So non-exclusive, good. Exclusive, better. So from your standpoint, if you've got an exclusive agreement, that grants you a lot more confidence that you're going to be able to make a deal for these people. Property type, it defaults to single family residential. So if you're just doing a single family residential property, then there's nothing to do. It automatically defaults to that. If you're going to use the form for some other type of property, vacant land, commercial, dock, anything like that, then you need to check the appropriate box and add any language in there. For example, there is no dock language, so you would have to put that under other if there's some other property type. And if you are excluding single family residence for some reason, you would check that box to exclude it. B2 is the location. So this defaults to typically counties. I would say that, you would probably check San Bernardino County, or you would check under city. You might put zip codes and add the zip codes. You can also use this additional description if you want to put, for these zip code areas. But I would probably, for our purposes, just put San Bernardino or San Bernardino Mountain Communities. Additional buyer preferences is optional. You can use this form BIPP if you want to have the buyer fill out a form that says these are the other preferences that they're looking for in their property. You're not required to do that. I probably wouldn't use that form. I probably would just do it the way I've always done it, which is have a discussion with them, try and get a feel for what their wants and needs are. But that form is available if you choose to add it to the document. And then paragraph D has to do with properties excluded from representation. So for example, if you talk to the buyer and they say, yeah, we made an offer on another property in Lake Arrowhead with another agent. We're not working with them anymore, but it could come back around, might circle back, and that would be an opportunity for you to put in that address here or a series of addresses, or to check the box and add a list of properties that the buyer has viewed or witnessed with other agents. So it's going to become important for you to ask those questions. Have you worked with anybody? Have you signed anything? And you would basically have the opportunity to exclude any properties in this area, so the buyer's not caught in a situation where they're obligated to two brokers. Skipping down to compensation. So E1 is amount of compensation. So this is the percentage of acquisition price. Typically, that's what you're going to use. You're going to use a percentage, either whatever it is, whatever number it is that you put in there that you're going to negotiate in for your commissions. Don't lowball it. Don't offer to put in a super low number there, because that is the maximum you're going to be paid. If you think along the lines that, well, I'm going to ask for this from the buyer, and then I'm going to get paid by the seller's agent, or I'm going to get paid by the seller, you're going to have a rude awakening when you find out that the only amount of money that you can be paid on a transaction is the amount that you have in this blank. So you're going to want to put whatever the actual amount that you're wanting to be paid. And then you can add in, if there's a transaction fee or there's some other dollar amount, some other fixed fee that you want to add to that. That's where you would add under this second area. Or you could be complicated and attach a compensation schedule. If there's some reason there's a certain price range that you're getting paid X, you could complicate it further that way. I just recommend that you put under E1 the percentage that you're looking for. Under E2, payments received by broker from seller or others. What this basically is telling the buyer, and you'll want to emphasize this with them, that anything paid by other parties. So if you receive compensation from the other broker, if you receive compensation from the seller, they're paying your compensation, that amount is deducted from the amount that is written on paragraph E1, which is what the buyer owes. And it also goes on to say that the buyer will not receive any amount in excess of what is on that line. So that's the actual confirmation that you cannot receive anything more than what is there. You can potentially go back and renegotiate, but that's going to be problematic after the fact. I definitely recommend that you do not do that. E3, continued right for payment for broker-involved properties. What that means is that for a continuation period after this agreement expires, so if you have a 3-month agreement, which is the maximum you are allowed to have, this gives you additional protection after that 3-month period for any properties that you had broker involvement with, or if you're an exclusive agent, any properties that they buy within that time period. So 30 days probably would be too short of a period. I'd recommend at least 60 to 90 days. Probably 60 days is probably going to be the best alternative for that representation period. Cancellation rights and notice. Non-exclusive cancellation is effective upon receipt, or you can put some date in there if you choose to, number of days after. But it is effective if it's non-exclusive for immediately upon the buyer wanting to cancel. If it is exclusive, the cancellation period is 30 days after receipt. So keep in mind that the cancellation, there is the continued right to payment after the fact. So if you have a buyer that's trying to get tricky and cancel on you so that they can turn around and buy another property with someone else without having to compensate you, you do have that protection in there as well. Paragraph G1, time to deliver buyer personal financial information. So it defaults to 5 days, and you can shorten that period. You could extend that period. That's up to you. But basically, you're probably going to want to get basic personal and financial information from the buyer earlier than sooner than later. But that's at your discretion. And paragraph G2, other financial considerations. So if the buyer just says to you absolutely that they do not have sufficient funds to pay broker, and the buyer intends to purchase the following loan product. So if it's a VA loan or it's something that requires or doesn't allow the buyer to pay fees, you're going to end up checking those boxes, and there are things that apply to that. Other terms is a blanket section that you can add other agreement terms or anything else that you think is necessary. The buyer will initial the bottom of the document, and then you will also initial the bottom of the document. Paragraph 3, advisories, addenda, and disclosures. So this is a defaulted defaulted portion of the document where the BCA, broker compensation advisory, talking about how compensation works, is automatically attached in the 13-page bundle. So it comes after this. And then if there's any other advisories or addenda that you would want to attach to this, you're welcome to do that as well. I don't know what there is, what that would be at this point. Paragraph 4 refers to the matrix up above in compensation. So it gives you, plain and simple, I mean, the reason for all these lawsuits is buyers and sellers claiming that they weren't advised that real estate commissions are negotiable. So again, you're seeing it here. You're also seeing it in the BCA, where it's a reaffirmation that real estate commissions are negotiable and not set by law. There are not any standard fees. Broker right to compensation. Broker shall be entitled compensation from the buyer if during the representation period or any extension, buyer enters into an agreement to purchase, lease, or otherwise acquire any property described in paragraph 2B, and the seller thereafter completes the transaction or is prevented from doing so by default of the buyer as follows. So it goes into the fact that it defines when the broker is due compensation. So non-exclusive, there has to be broker involvement in the property, and we'll talk a little bit more about that a little bit later. Exclusive representation, it means that if the transaction closed or if the buyer did something to default, then the compensation could be due. So buyer includes any person or entity other than the broker related to the buyer, or in any manner acts on the buyer's behalf. So basically, if a guy has his wife substitute in and he says, well, I signed the buyer broker agreement, but my wife didn't, this is also additional protection that they're really acting on behalf of that entity. Broker involvement, you have the multiple ways that the broker involvement can be established. Property was shown, if the property was virtually shown, if the buyer submitted an offer, if the broker performed a market analysis related to the property was introduced to the buyer by a broker, and they have to have done something. It can't just be a list. There has to be some involvement that they can document with that property. Maybe they talk with the seller about this particular buyer and the potential of them purchasing it, something like that. That's going to be a kind of a gray area where I could see that there's going to be some issues, but that does constitute broker involvement. Paragraph C, continuation of right to compensation. This is talking about the extended right. The broker has to provide a list of the properties that there were broker involvement in. If it is for a buyer broker agreement that's expiring, then that list needs to be delivered prior to it expiring, or any continuation, like an extension of that. So when that extension is ready to expire, that would be when they would have to provide the list. If it is a cancellation, then there's a special provision where the agent has the extended time period of 5 days after the cancellation for the list to be delivered. So you have that protection. Timing of compensation, not really much different here. This is basically saying when is compensation payable, having to do with the completion of a transaction where the buyer would be obligated to pay the broker. So as soon as the transaction closes, if for some reason the buyer defaults, then upon the buyer's default, technically the compensation could be owed. Not sure where that goes or who enforces that, or if someone would enforce that. And then there's another provision if acquisition is prevented by a party to the transaction other than the buyer. And if the buyer collects damages, then you subtract off whatever the cost of the damages is, and then the broker would be entitled to half of that. So if they were to sue the seller, get damages from the seller, whatever the costs were, deduct that, and then the broker technically would be entitled to half of whatever those damages are. Payment through escrow is authorizing escrow to be notified that the broker should be paid through escrow at the close of escrow. Accounting for payments to broker if the broker also represents the seller. So this is a paragraph that's talking about the fact that I already said that any monies paid by others will offset the amount owed by the buyer. What this is saying is that you don't count any monies that the broker is being paid for representing the seller. So technically they're being paid by the seller to represent them. If the buyer has an obligation, you can't subtract those monies because they are different. Those are for representing the seller, not representing the buyer. Think of it this way. Any monies that the broker is paid that is being paid as a result of the buyer owing the money, that is when it is offset. So you won't be able to double dip. But this paragraph clearly states that the seller's side has nothing to do with whether or not they would be credited any money. Payments received from others less than the buyer's compensation obligation. So under this circumstance, this is causing the conversation that if the broker is offering less than what the buyer owes its broker, then it gives the authority to the buyer's broker to request through the contract for the seller to pay what is owed to the buyer's broker by the buyer. So this is basically, let me read it to you. A broker and buyer should discuss whether it would be beneficial to include a term in any offer buyer makes obligating seller to pay the broker. So it forces that conversation. And then it says if seller does not pay as contractually required, the buyer assigns to broker as a third-party beneficiary any rights. So let's say if the seller agrees to pay the broker and then they don't in the end, in order for them to be able to pursue the seller for the monies that they're owed, they would have to have the authority, and this paragraph gives the authority to the buyer's broker to go after the seller if necessary. Disclosure of payments to broker independently or through escrow will disclose the final compensation broker receives from anyone other than the buyer. So required that the broker must disclose everything that they're being paid. Cancellation of buyer representation agreement. Either the buyer or the broker may cancel the agreement by giving written notice at any time to the other within the time specified in paragraph 2F. So it basically is either immediate if it is non-exclusive. If it is exclusive, it is 30 days, or unless it is changed to some other time period, some other number is put in the paragraph. Again, buyer's initial, broker's initial. Page 3. Broker shall be entitled compensation if during the representation period or continuation period specified in paragraph 2E3, so whatever that time period is, buyer acquires property for which there was broker involvement, provided broker delivers a buyer a written list of those properties for which there was broker involvement. So this has to do if there's a cancellation. So 5 calendar days is the effective date of the cancellation. Buyers advised to notify any other brokers of brokers' rights under this paragraph. So this is again telling the buyer, hey, I could be on the hook. You could be on the hook. You need to make sure that any other brokers that you might go and talk to after the fact, let them know that you are under a written agreement, because you don't want to get caught up in a situation where you end up having to pay 2 commissions to 2 different brokers. Agency relationships, again, this is fairly standard stuff talking about the AD, that the AD is included in this package and an addendum to this document. Possible dual agency with the seller. It outlines the fact that California, there is dual agency is permitted by law, and there's an automatic check marks into possible representation of more than one buyer or seller. So the PRBS is automatically incorporated into this document. Properties excluded from representation, paragraph 7. So this is an advisory, just basically explaining to the buyer, hey, you want to be careful about signing multiple buyer representation agreements. It can get you caught up in a situation. Make sure you understand what you're signing. Make sure that you disclose to others that you are obligated, that you have signed some paperwork with another agent. And you're going to be asked, hopefully, any professional agent is going to ask you, but, please make sure that you are notifying any other brokers of what agreements that you have in place. Conflicts with other brokers, unless otherwise notified by buyer acknowledges that for the property identified, so on this particular property, they're basically indemnifying that, and they're telling the broker that there isn't anyone else that they are obligated to. They have no other obligations, even under a non-exclusive representation agreement, which I would be careful about that. If they've signed an exclusive representation agreement in a broad area, that could cause some issues for you. So this is basically just the buyer attesting that there are no conflicts. Limitation on broker representation. And again, this basically gives an out that if for some reason the broker just doesn't feel that they're going to be able to make it work with this buyer, and the buyer has no money, they have no ability to be paid, this releases the buyer's agent from the obligation to do the transaction for nothing. So it does give them the right to back out on this specific property. Let me read that to you so that it's maybe a little bit more clear. Limitation on broker representation. If a property is excluded under paragraph 2D, during the time buyer is obligated to compensate another broker is not obliged to assist the buyer with respect to that property, and the buyer shall not owe broker compensation under that agreement for that property. So that's not exactly what I just said it was. I'm thinking of a different paragraph. What this is saying is that if there's an obligation to another broker, that other broker is going to get paid. Okay, they have the right to be paid. If the buyer comes to you and says, "Look, I don't care about that. I want you to represent. I want you to take care of it for me. I don't want to work with them." This basically says that you're not obligated to do that. You're not obligated to work for free. Now, if they want to pay you a commission, they want to pay the other guy and pay you, that's one thing. But if they're asking you to do them a favor because they don't like that other guy, you're not forced to do so. And it reiterates that the buyer is not required to pay compensation under the agreement for that particular property. So that's what paragraph 7C is all about. Broker's authorizations and obligations. This talks about all the things that the broker is obligated to do, what they are to help the buyer with. I'd recommend that you read through this and just have an understanding, but it's all the stuff that you would normally be accustomed that you would do. Buyer obligation. There's fewer buyer obligations, but one is good faith. The buyer's agreeing that they will act in good faith. They're also stating that they will provide relevant personal and financial information so that they can, the buyer's agent can adequately help them, and that the buyer's agent knows that they have the wherewithal and the ability to actually make it happen. Buyer's initials, broker's initials. Paragraph 9B2. So if you remember back, there was a box that was checked that the buyer said that they don't have they have no way of paying the buyer brokerage, and or they are doing a loan that would not allow them to pay buyer's costs. And if the seller will not agree, or you cannot come to terms, which I think is pretty unlikely, but if that were the case, it gives the authorization for the buyer's agent to include a term requesting the compensation on the buyer brokers. And if, for example, they don't do it, it does give the buyer's agent an opportunity to say, look, I can't help you with this transaction. It releases you of the responsibility and the fiduciary. It's kind of a weird clause because I don't know, typically agents are not going to want to do that, but it solves the problem where you're not having to be forced to represent this buyer in this transaction gratis and have all the liability that goes along with that and not be able to be paid. So so at that point, it gives the buyer's agent the right to tell the seller that the buyer is going to be proceeding without representation. They're not going to do it for free. Paragraph C, reasonable care and other professional assistance. Buyer's obligated and agrees to read all documents. Buyer agrees to seek desired assistance from appropriate professionals, accountants, whoever it is that they need that are professionals, including an attorney. Buyers advised to read the attached buyer investigation advisory for a list of items and concerns. So again, just providing the buyer with some instructions on things they need to be doing, okay, things that they need to be responsible for. Reports, investigations. This is where the buyer is agreeing to pay for whatever reports, investigations, and meetings that the broker arranges on behalf of the buyer. Buyer material issues. This is where the buyer agrees that they will provide and explain to the buyer's agent anything that comes up that would become a material issue. And there's a form designed for that, the BMISP, where the buyer can let the buyer's agent know if there's anything that is material that about this specific property that they want to have addressed. Incorrect or incomplete or inaccurate information, again, is a paragraph basically saying that the buyer is indemnifying the agent if they give bad information or they give inaccurate, incomplete information, and some kind of a claim or dispute arises as a result of that. Attorney's fees means everybody is going to have to pay their own attorney's fees unless things are mediated. There are some provisions that could allow for attorney's fees to be awarded. Management approval gives 5 days for management to approve any of these agreements. And then dispute resolution is the same as it usually is, mediation. And then the exclusions to mediation, which would be foreclosure, small claims action, lis pendens, those types of things are exempt from forcing a party, either a buyer or a buyer's agent, to mediate any dispute prior to any kind of litigation. Legally authorized signer, wherever the signature, it explains basically representative capacity and who the legally authorized signer is, and the buyer is acknowledging that they are certifying they have the right to sign as a legally authorized signer, and that the entity that they are signing for is in good standing in the state of California. So it is, basically firming up that responsibility of signing for an entity. And then paragraph 14 is the blanket statement that this is the entire agreement. And this is what governs the agreement between the buyer and the seller. Buyer will initial here, seller will initial, buyer's agent will initial here. And then on the first page, if we were to check the box exclusive, I mentioned to you that there was going to be a separate acknowledgement that the buyer must acknowledge that they understand that they are entering into an exclusive agreement and what that means. What are the differences? So they can't come back and say, well, I didn't know that I was in an exclusive arrangement. I thought I was in a non-exclusive. Well, they signed on the first page and they're initialing in a boxed off paragraph with bold print. So they won't really have that opportunity to state that. Something a little tricky here on 16 is this is the area where you're going to confirm the compensation. And the reason why they have this is so that when you have to provide proof of what your compensation is as a buyer broker, you're going to have to provide that to escrow in order for them to uh, uh, pay you. And secondly, it also needs to go to the listing agent and the seller so that they understand. They may ask for proof on to make sure that the SPBB that you are issuing, asking them to pay the compensation, they need to know that you're actually due that compensation. So whatever that compensation is on the first page, you want to make sure that that goes in this on this line right here. And then this box needs to get checked. If this box doesn't get checked, this may not apply. And that could cause some confusion here. And so you're going to want to make sure that this box is checked. And then as well, if there's any additional transactional fees or anything like that. And then if this was a flat fee or there was some other dollar amount rather than a percentage that's owed, that would be here. And then as we talked about, specified in the attached agreement, if there is a separate sliding scale or some other means where there is a schedule, you would attach that separately. So buyer is going to acknowledge and that they have read and they understand and they've received a copy and agrees to the terms of this agreement, and they're going to sign below here. So you would check entity buyers if it's an entity, if they're buying on behalf of a trust or there's some other entity, corporation, LLC, partnership, whatever it is, you're going to use this box checked, and then you would have the name of the legally authorized signer, and then the full name of the entity, including the probate number or additional identification numbers you would list here. And then down below here, if you've got authorized signer, you would check this box. If not, you would sign it. The normal buyer would sign it. If there's a second buyer, you would sign it here. And then obviously you as the broker would be signing down below here. And you can add, if there is a multiple broker situation, you can add the AAA document. Or you can add the ABA document if there are two brokers with different companies that are representing the buyer. So that is the BRBC. Hopefully that gives you a general enough or broad enough overview so you understand how you're going to complete it. And if you have any questions or concerns, don't hesitate to reach out to me so that we can talk about it.